My name's John Hendy, and I welcome you to this seminar given by the Old Square Chambers. We've got three excellent speakers this evening to talk about human rights and employment law. I hate the term human rights lawyer because it always seems to me that any lawyer has got to be a human rights lawyer, because it doesn't matter what field you specialise in, from conveyancing, taxation, crime or employment law, you've got to know about the human rights aspects as well. So that's what we're going to be looking at this evening, the human rights aspects of employment and industrial relations law. But just to satisfy you that we are competent to talk about these things, I thought I'd just review with you the 12 cases that we have either had dealt with or are pending in the European Court of Human Rights from these chambers. Some of them are going to be spoken about by my colleagues later on. I think the first case in the list is a case called Unison in the United Kingdom, which I always regard as a draw, and that was a challenge to restrictions on the right to strike, where the European Court held, yes, the right to strike had been restricted, and that was a breach of Article 11.1, but no, that was not an illegitimate restriction. It was justifiable under Article 11.2. That was a dispute about future terms and conditions. Second case is a case called Wilson and Palmer in the United Kingdom, which is basically where the European Court upheld the right of unions and union members to seek collective bargaining and the right to be heard by the employer, even to the extent of industrial action to procure that if necessary. I think Ben's going to speak about Wilson and Palmer. Third case is Aslef in the United Kingdom, and there the European Court of Human Rights upheld the right of a trade union to decide its own rule book and decide its own membership, and in that case the right of the union to expel fascists. The fourth case, which has been decided, is a case of RMT in UK, which is about the right to strike, decided on the 8th of April this year. Very important case and one which I feel very, very bitter about. So Ben's going to talk about that case. Two further cases just to mention, which were dealt with at the end of last year. One brought by Unite on the behalf of cabin crew arising out of the British Airways dispute, where we were challenging a discriminatory penalty which had been imposed on workers. That was knocked out on the grounds of inadmissibility on the basis that we were out of time. Unfortunately, that wasn't a point raised with us by either the government or the court, because if it had been, we would have said, no, it can't have been out of time, because it was a continuing penalty and continued indeed for many months after the application was put in. But as you appreciate, there's 120,000 cases outstanding in the European Court of Human Rights at the moment. Consequences, they knock out every case they can on a technicality. And that comes to the other case I was going to mention, the sixth in line, which is the Prison Officers Association against the UK, which was over the denial of the right to take industrial action to prison officers. And we were knocked out on that one on the basis that we'd already made a complaint to the International Labour Organization, and that was incompatible with bringing an application to the European Court. So those are the 6 cases that we've had dealt with. We've got another 6 which are pending. One is called Brough in the United Kingdom, which Ben's going to mention, which is about blacklisting. He doesn't know, because it was only lodged about 2 weeks ago, that there's another one on blacklisting called Smith in the United Kingdom, which raises the same issue. Then we've got a case called Matu in the United Kingdom, which is all about Article 8, and I know Nicky's going to say something about that case, at least the English litigation that led to it. Then we have, tenthly, Unite in the United Kingdom, which was a challenge we put in last year over the abolition of the Agricultural Wages Board on the basis that that was a breach of the right to collective bargaining, which the European Court of Human Rights had held was an essential element of Article 11 of the Convention. And 11thly, I know Ben's mentioned this one in his paper as well, the Irish Congress of Trade Unions against Ireland. So there's an instruction from an Irish firm of solicitors, which is a challenge to a case in their Supreme Court last year called McGowan, which is really undermining a collective bargaining structure established by law in Ireland. I don't think we need to go into the technicalities of that. I said there were 12. In fact, there are 11, and those are the 11. So without further ado,